Thank you.
Justice Kagan?
Yeah, if you could just talk a little bit about that, because as I understood it, for example, I read recently that the hospital that has the greatest emergency room services in Idaho has, just in the few months that this has been in place, had to airlift 6 pregnant women to neighboring states, whereas in the prior year, they did 1, the entire year. So if Mr. Turner is right about what the state is trying to convey to hospitals about when they'll be prosecuted, like, why is this happening?
I think that the reason this is happening is because those doctors can look at the text of the statute itself. They can look at the Idaho Supreme Court's decision, which made clear, very clear, that this was a departure from prior Idaho laws that tracked EMTALA, and they can recognize that their livelihood is on the line, their medical license, their ability to practice medicine, their freedom if they have to go to jail and serve one of these minimum 2-year sentences of imprisonment, and they simply cannot provide the care even consistent with their subjective medical judgment, because as a matter of medical reality, for many of these conditions, it's not yet putting a woman at the brink of death or necessary to prevent her death, yet they know that the standard of care is to provide her with termination, because she is just going to get worse and worse and worse if they wait it out. And the other important point about this, and I think it goes back to this dual stabilization idea, is that tragically, in many of these cases, the pregnancy is lost. There's not going to be any way to save that fetus, because a woman who has PPROM at 17 weeks, there is no medical way to sustain the pregnancy to give the fetus a chance. So in that situation, what Idaho is doing is waiting for women to wait and deteriorate and suffer the lifelong health consequences with no possible upside for the fetus. It just stacks tragedy upon tragedy.
And it can't be the appropriate, you know, it's become transfer is the appropriate standard of care in Idaho, but it can't be the right standard of care to force somebody onto a helicopter.
And it's entirely inconsistent with what Congress was trying to do in the statute. You know, one of the primary motivators here was to prevent patient dumping. The idea was we don't want people to have to go somewhere else to get their care. You go to the first emergency room in your state and they have to treat you and stabilize you. But this effectively allows states to take any particular treatment they don't want their hospitals to provide and dump those patients out of state. And you can imagine what would happen if every state started to take this approach.
A question on the spending clause questions that you've been asked. I mean, what would, if you accepted some of these theories, what would the consequences of something like that be that we would have to worry about?
I think that it would call into question any number of federal spending statutes that provide funds to private parties, and there are a bunch of them. You know, there's the Medicare system itself, which is, of course, a major federal spending program. There are funds provided under Title VI, under Title IX, a lot of federal statutes out there that give funds to private parties and insist on conditions of compliance with the federal funding restrictions. And if the court were to suddenly say that can't preempt contrary state law, then I think that it would seriously interfere with the ability of the federal government to get its benefit of the bargain in those spending programs.
And you mentioned before that this question has never been a part of this case.
That's right. They did not make these arguments in the lower court. They briefly referred to the spending clause, but I don't understand them to have pressed this argument specifically. And so I think that the lower courts did not address it. I think the district court said in a footnote, they briefly referred to it in a footnote of their brief, and it's essentially waived.
Thank you.